Welcome, everyone. C'est un grand plaisir de vous accueillir tous et toutes ici. It's a great pleasure.
It's my pleasure to welcome you today.
In human rights, we're going to be talking about the review. We're going to be reviewing the appointment process for Supreme Court justices. It's an enormous pleasure to have with us today our Minister of Justice and Attorney General for Canada, Jody Wilson-Raybould. Thank you for coming, Minister. And of course, a great honor to have former Prime Minister, the Right Honourable Kim Campbell, here with us too. Ms. Campbell is the chairman of the Independent Advisory Board for Supreme Court of Canada Judicial Appointments. So ladies, the floor is yours to begin.
Well, thank you, Chair and members of the committee for convening this special session of the committee, and really appreciative, certainly, of everyone for being here, and certainly the lady to my left. Pleased to discuss Mr. Justice Rowe, and the purpose of this meeting is twofold. One, to discuss the government's selection of Mr. Justice Malcolm Rowe of the Court of Appeal of Newfoundland and Labrador as the government's nominee to the Supreme Court of Canada, and two, to describe the process that led to that selection. This will allow Canadians to understand the process that has been used in nominating Justice Rowe, and will allow you, as parliamentarians, to hold the government to account. I know how busy the committee members are, and I greatly appreciate the time that you are devoting to this process. I am, of course, joined by the Right Honourable Kim Campbell, who served as the chairperson for the Independent Advisory Board for the Supreme Court of Canada Judicial Appointment. As you know, the Advisory Board has been the heart of the government's new appointments process for the Supreme Court. 7 distinguished individuals served on the board, including 4 nominated by independent professional organizations. In addition to the chairperson, the Advisory Board includes a former judge, 3 members of the legal profession, and 2 non-lawyers. The Advisory Board's work has been integral to creating an independent, transparent, and nonpartisan selection process for the Supreme Court of Canada. I would like to express personally and on behalf of the Prime Minister and our government our sincere gratitude to each of the Advisory Board members for their outstanding work and dedication to this process. I would also like to thank the Canadian Judicial Council, the Canadian Bar Association, the Federation of Law Societies of Canada, and the Council of Canadian Law Deans for nominating such excellent individuals for this critical task. Shortly, Ms. Campbell will describe the steps the Advisory Board took in creating the shortlist that it provided to the Prime Minister on September the 23rd. I know that arriving at that shortlist of exceptional candidates required many hours of painstaking work, carefully reviewing all the detailed applications and undertaking extensive consultations to assist in assessing each candidate against the published qualifications and assessment criteria. The value of these efforts was reflected in the excellence of the shortlist that the board produced, and is, I believe, clearly demonstrates the outstanding qualities of the government's nominee. Our appreciation also extends to all those who were consulted throughout the selection process. The informed views and insights of those who know the candidates personally, who understand the demands of a judicial role, and who can advise on the institutional needs of the Supreme Court are truly invaluable in reaching the final selection of the nominee. Special thanks certainly are due to Ms. Campbell for her able leadership in chairing the Advisory Board. I'm honored to be appearing with her today. Our connections run deep. Not only did Ms. Campbell serve as a member of Parliament in the heart of Vancouver, she's opened many doors for women in the law and beyond, and served as Canada's first female Minister of Justice. I'm proud to be among her successors in that role. She was the perfect choice to chair the committee of the Advisory Board, and I'm delighted she agreed to do so. The government is also indebted to the Office of the Commissioner of Federal Judicial Affairs for the outstanding secretariat support they provided to the board. Quite simply, this process could not have happened without the professionalism, efficiency, responsiveness, and experience of the Commissioner's office. I know that many staff worked tirelessly long hours throughout the summer and the fall to pull this together, and for that I'm very grateful. And last but certainly not least, I would like to extend my heartfelt thanks to all the candidates who applied for the vacancy. It goes without saying that this process could not have succeeded without their willingness to participate, and I recognize that making a decision to apply was not one made lightly or without personal cost. I said when I appeared before you earlier that I knew it would be a humbling task to make a choice among so many outstanding candidates. That prediction proved truer than I had imagined, and I can only say that I feel tremendous pride at the remarkable level of legal excellence in this country. Let me now briefly review what has brought us here or to this stage of the process. Our government made a commitment to establish a new process for the selection of the Supreme Court of Canada justices, one that is open, transparent, accountable, inclusive, consultative, and one that promotes diversity. We also promised that appointees would be functionally bilingual. Through the collective efforts of all those involved in the process, I believe we achieved those objectives. Canada has an outstanding Supreme Court. It has long been a source of pride for Canadians and a source of inspiration for other countries. We are blessed to have an exceptional cadre of men and women who served on the court up to the present day. But the process for selecting the court's justices has not always matched the excellence of its jurists. The process was often ad hoc and opaque and did not meet evolving norms of openness, transparency, and accountability. In short, a modern, dynamic 21st century court needed in a modern, dynamic 21st century selection process is what we are moved towards. The initial step was key. We opened up the process and established the first application-based approach to identifying qualified candidates for the Supreme Court. Anyone who met the statutory eligibility criteria could apply. This was a significant departure from past practice, which involved either the proverbial tap on the shoulder or, in some more recent cases, saw an initial long list of candidates developed by the government itself on the basis of closed consultations. Applications were invited from anywhere in the country to support our goal of ensuring that our highest court moves towards a better and fuller reflection of the diversity of Canadians. This was also to ensure that the most outstanding jurists in the country, regardless of where they live, have the opportunity to be considered for vacancies as they arise and for which they are eligible. I recognize the concerns expressed by some that this opening up of the process occurred at the expense of ensuring regional diversity on the court. With great respect for the sincerity of those who feel this way, I do not share this view. The breadth and depth of expertise on Canada's bench and bar in every part of the country is quite remarkable. I am convinced that, at any given time, there will be outstanding individuals across Canada who will choose to put their names forward for a given vacancy. This will ensure that the Supreme Court's regional character is maintained. Moreover, and in the context of the current process, the Prime Minister specifically directed the Advisory Board to include candidates from Atlantic Canada on the shortlist, in recognition of the custom of regional representation and the fact that Justice Cromwell hailed from the region. Our commitment also included a requirement that the shortlist only recommend candidates who are functionally bilingual, given our country's bilingual character. As we expected, there was a rich pool of outstanding candidates reflective of the diversity of Canadian society who met this requirement. And those who potentially aspire to serve on the Supreme Court in the future are now aware of the expectation. The process we have adopted has generated widespread public interest and debate, which is itself a positive thing. Canadians care deeply about their Supreme Court and the critical role it plays in our democracy. We believe this process has sufficiently advanced the goals of openness, transparency, accountability, and excellence, and a court that reflects the faces and the voices of Canada. In light of this experience, it is our intention to follow this process for filling future Supreme Court of Canada vacancies, subject, of course, to further refinements that may be suggested by this committee and by the advisory board. We believe our selection process is in keeping with the values of Canadians today, and that it will remain a modern, and that it will support a modern Supreme Court of Canada that is reflective of and responsive to those values. I would now like to turn the floor over to Ms. Campbell to allow her to describe the process that the advisory board went through and its mandate, and then I'll provide some concluding remarks. Over to you, Madam Prime Minister.
Thank you very much, Madam Minister. Peut-être je peux dire quelques mots en français pour dire que comme ça.
Just like to say a few words in French, just to say that I'm very, very happy to here with you today. And it's really wonderful to see the environment here, and I certainly respect all the work that you are doing here together.
Of all of the members of the Independent Advisory Board, how honored and delighted we were to be given this task. And I can tell you that it was a great honor for me to chair a remarkable group of people. And when one of them said, when I was able to call on Monday and tell them who the Prime Minister's nominee would be, one of them complimented me as chair, and I said it was like conducting the Vienna Philharmonic. They really were a wonderful group of people devoted solely to producing the very best possible list of candidates. And as we said, our goal was to create a list that would keep the Prime Minister up at night, trying to figure out which one of these excellent people to appoint. So shortly after our appointment was announced, we convened by conference call. Time was limited. The announcement went out August the 2nd, and the deadline was August the 24th. So we wanted to use that time as expeditiously as possible. And one of the terms of reference was for us to reach out and solicit good candidates for the court. So the first thing we did was to send the materials to all of the organizations represented on the committee, and then to reach out further to every other organization of lawyers that we can think of in the country. And I said I thought we should err on the side of overkill. So every possible kind of organization, I think there were about 19 different organizations in addition to the 4, the Canadian Judicial Council, the Canadian Bar Association, the Federation of Canadian Law Societies, and the Association of Law Deans. Where we occasionally received in reply to these missives letters recommending individual candidates, we immediately sent material to those individuals and said, your name has been strongly has been put forward with strong recommendation that you would make an excellent judge in the Supreme Court of Canada. Please review these materials, and if it interests you, we warmly encourage you to apply. And that did, in fact, encourage some people to apply. And this is something that we can talk about later. One of the interesting transitions of this is that we all know that for many senior members of senior jurists and senior members of the profession, the idea of applying is sometimes a difficult thing to do. So finding ways to encourage people to apply was something that we wanted to do. And we were very delighted that there was a good response. We met in August in Ottawa on August the 16th to in person to discuss the process that we would pursue and to have a meeting with the Chief Justice. Chief Justice McLaughlin was available at that time, and that meeting where we had a very good conversation with her about what it actually means to serve on the court, what are the things that actually help someone to succeed in that court, and what are the needs of the court, was very, very helpful to us, and we were very grateful to her for the time that we spent with her. And it was a very open conversation among the members of the committee and the Chief Justice. So we received 31 applications. I won the pool. I had guessed 32. So I won the envelope of toonies that we had put together. You are shocked to hear there was gambling on that committee. But it was a number that was very reassuring. Because 31 applicants from all across Canada, almost all of whom had some French, or met the standards of French. Only a very small number did not have French. at all, and most of them had considerable French. That was very interesting for me to see. And I want, again, to echo the words of the minister in thanking all of the people who filled the applications. It was a long application form, and interestingly, almost the more senior you are, the harder it is to go back and dig up that material because you think you're never going to apply for anything again, and there you are having to recreate your life. But people did it, and I know that the deadline was August 24th at midnight Vancouver time, and for those in Eastern Canada, that was a good thing because some of them, I think, were sending off their applications at 2 in the morning their time, but happily we got them. So after the Office of the Commissioner for Judicial Affairs did a wonderful job of taking all the applications and loading them onto secure tablets, and also printing them out so that each of the members of the committee had binders with the printed versions, but also we had secure tablets that we could take with us because they were password protected, so that we could review the materials. But we came to Ottawa on the morning of Monday, August the 29th, and really began in earnest to do our work. I won't go through all the details, but I do want to just give you a little idea of the philosophy, certainly that I had as chair, and that we brought to the exercise, because I'll let you will have your own questions. But one of the things that was important from my perspective was that every person who applied would know that he or she was getting a full and fair review. And so what we did was we started off in taking groups of candidates and each of us going off separately to review the applications so that there was no groupthink, there was no influence one of the other, that we each looked knowing what the terms of reference were, knowing what the criteria were to develop our perspective on the individual candidates. Then we came together to see where there was consensus, where there was disagreement, and where there was disagreement to try and discuss more fully the nature of the candidates. We also realized that we would obviously need to take 31 candidates and reduce it to a manageable size. The Prime Minister would only appoint one, and the maximum number of names we could send to him was 5. So we began to work to whittle down the list, and we decided that we would interview 10 candidates. And I have to say that, the Commissioner's office was incredibly helpful in setting up appointments for us to talk to references, and we spoke broadly to Chief Justices and senior members of the bar across the country about various candidates, and had great cooperation. And the candidates themselves were incredibly cooperative about finding time to fit within our schedule to come to Ottawa for a full interview. We developed a questionnaire for the referees so that each person got the same questions, although we always had an open-ended question at the end, but so there would be comparability. We created a script of questions to ask the applicants so that, again, there would be comparability in terms of their responses, and I think it was a very good questionnaire. We allowed an hour for the interviews, although I will say Justice Rowe, as you will find, is a man of few words, and I thought we were going to have the interview was going to be over in 10 minutes. But as soon as we asked him to elaborate on some issues, we got a lot more information. So some people are more succinct than others, but all of them had extraordinarily wonderful stories to tell about their own lives, but also very, very interesting and often very, very nuanced understandings of the law and the role of the court. So we interviewed the candidates, and immediately after each interview, the candidates went upstairs to do the functional bilingualism test. If they were Francophones, it was in English, and if they were Anglophones, it was in French. Also, during the interviews, they were asked questions in both languages. So the candidates themselves were extremely helpful in accommodating their schedules in the summer, in August, when many of them, I think, probably hoped they could stay at their cottages. But interestingly enough, they came for the interview, which is wonderful. So then we deliberated, and that was the hard part, was to deliberate to create a short list of 5 candidates. And I'm glad it was hard, because what that reflects was the richness of the applicants. It's very, very difficult, and I think it's important to say that there is certainly no shame in being one of the applicants for the Supreme Court of Canada and not being the one who's appointed, because all of the people whose careers we reviewed, and certainly the people, even more so perhaps the people that we interviewed, were really remarkable. and any one of whom could have served with distinction. And our job was to try and find the most promising, the most accomplished. And it was not an easy task, but it was a very reassuring one. It was a wonderful, wonderful thing to see. And I was actually also very pleasantly surprised at the level of French competence among the applicants. Again, that, as the Honourable Rob Nicholson will remember, in our days many years ago in Justice Together, the judges and lawyers were learning French. Even out west, it was sort of becoming the thing they wanted to do. And I must say that this is something, I mean, Justice Rowe represents the same kind of the commitment of Anglophone jurists to become part of that national conversation. And I think that was really great. So let me just finish by saying that from our perspective, the values of the process were, first of all, the open application. The fact that you didn't have to know somebody. And I think in the past, prime ministers and their ministers of justice have always tried to find very good people. But as all of us who've fought to increase diversity, to increase the representation of non-prototypical people in various fields, we know that sometimes people just don't notice those who are not like them or who are that they don't encounter in their daily lives. So having a process which basically allowed any lawyer in Canada to put himself or herself forward for consideration, I think was really wonderful. It meant that if you weren't in the gaze of the normal advisors, you still could be considered. And of course, as I say, we felt that our moral obligation was to give each of those candidates the fairest possible review and to include them in the process. And secondly, the fact that our review was an independent and nonpartisan review. Our whole focus was to look for competence. The government has its own, views about. They may have a view about a philosophy, whatever. Was not our view. Our view was to provide to the Prime Minister a list of candidates who were very, very competent and who brought with them a richness of perspective that would be an adornment to the court. The fairness measures that we did, as I said to you. First of all, we considered the candidates by numbers so that we didn't even get caught up in calling them by name in case that would have created a kind of, any kind of early stage bias. We sort of just looked at them in terms of their qualities, which they had revealed in great detail in those difficult application forms. The fact that we reviewed them individually as individuals before we came together to share our perspectives to make sure that there was no influence that might keep somebody from standing up for a candidate, because it's very important. Sometimes two people will read an application and they'll see it slightly differently, and so one person may say, another person will say, but look at this, and you go, oh yes. So there was a lot of that attempt to try and maximize the appreciation for the applicants. As I say, consistent questioning for the references, consistent questioning in the interviews so we could create a comparability. Also, each interview was debriefed immediately after with a note taker so that we didn't rely on remembering what had been said or even our own notes. As soon as we had finished an interview, we sat down with a note taker and went around the table and debriefed in great depth so that those impressions would be vivid when it came time to consider the ultimate challenge of creating a short list. Challenges for the future. I think the process was remarkable, and I was pleased that as I went about the country doing other things quite unrelated to the advisory board, that members of the legal profession spoke to me of their happiness with this idea. Particularly, I think the openness of the application and the fact that the review was by a group of people who had no agenda other than to try and find excellence in its many different forms that it takes. But the timing of the process was tricky. August is not the optimal month. It's not just in Europe that everything closes down in August, and people whose assistants or secretaries were on holiday were really having a hard time putting the story of their life together. But they did it. They were remarkable. The length of the process and a possible revision of the applications, just having more time. I think for some people it was a bit of a pressure to do it, although people did it. But if there is possibly more time, that would be great. And challenges for the future, I think outreach and recruitment. I think having once done this, the importance of making sure that people know what the process is and that talented, interesting members of the legal profession, whether jurists or members of the bar, know what the process is, and that all members of the legal profession and communities encourage people that they think have wisdom and skill to think about it and perhaps prepare themselves for the process in the future. So thank you for welcoming us here today. I'm very pleased to have been part of this process, and I very much look forward to your questions.
Thank you. Thank you, Ms. Campbell. And just let me now turn to the merits for the considerations that the government put in terms of the nominee himself. And as I've indicated, the quality of the candidates on the short list from the advisory board were outstanding. And my task of reviewing the candidates and arriving at a recommendation to the Prime Minister was an incredibly difficult one, to say the least. And I recognize that this is one of, if not the most important responsibilities that I perform as a Minister of Justice, and I took my responsibilities incredibly seriously. In terms of the consultations, I consulted with the Chief Justice of Canada, the applicable provincial and territorial attorneys general, members of this committee and the Senate Committee on Legal and Constitutional Affairs, the opposition justice critics, and members of Cabinet. I then presented the results of these consultations to the Prime Minister along with my recommendation. And while I obviously cannot reveal the content of these consultations or my advice to the Prime Minister, I can say that I am convinced that Justice Rowe would be an outstanding addition to the court and would continue to serve Canadians with great distinction in that role. In terms of Justice Rowe's qualifications and why the government chose him as its nominee, Justice Rowe has extensive appellate court experience, having been appointed to the Newfoundland and Labrador Superior Court in 1999, and then 2 years later elevated to the Court of Appeal in 2001. He is a jurist of exceptional quality in both the strength of his legal reasoning and the clarity of his writing. His judgments, evidenced by his ability to understand the social context in which legal disputes arise and to appreciate the diversity of views, perspectives, and life experiences, are evident. Born and raised in St. John's, the son of a fisherman, Justice Rowe's varied professional career lends a depth to his decision-making. Before he was appointed in 1999, he had an impressive career as a litigator in Ontario, becoming Queen's Counsel in 1992. Prior to that, he was a Foreign Service officer at the Department of External Affairs. There, he worked on critical international disputes with France and the EU concerning Atlantic fisheries, alongside such counsel as Ian Binney QC. He was then appointed as Deputy Minister to the Premier and the head of the Civil Service in Newfoundland and Labrador. During this time, he coordinated efforts to achieve a constitutional amendment to create a public, non-denominational school system in the province. His wide-ranging experience in both public practice and the public service will bring a rich and nuanced perspective to the court. Furthermore, Justice Rowe has an impeccable reputation both personally and professionally. A man of integrity, his career exhibits a strong commitment to public service and combines rigorous legal knowledge with open-mindedness and respect for others. This includes his activities with Action Canada, a youth leadership development program where he came to know and mentor future leaders from a range of backgrounds and experiences. Regional diversity was also an important consideration. Hailing from Newfoundland, Justice Rowe brings a unique perspective that has never been present on the Supreme Court of Canada. As for all of these reasons, the government chose Justice Rowe as the individual best suited to fill the current vacancy on the court and fill the large shoes left by Justice Cromwell. And let me just add that the government is delighted to have nominated someone who would be the first jurist from Newfoundland and Labrador to sit on the Supreme Court. Justice Rowe would continue in a long line of outstanding jurists from Atlantic Canada, serving all Canadians of our highest court, or on our highest court. It is with pleasure that I am able to present before this committee with Ms. Campbell, and we are very open to answering your questions at this time. Thank you very much.
Thank you very much, Lady ladies, and thank you very much for your compelling testimony. And Ms. Campbell, on behalf of, I believe, all of the members of this committee, I want to thank you so much for your service, not only to the country before, but for your service to the country since you've been Prime Minister, including this task, this very daunting task of helping choose a Supreme Court Justice. And I also want to thank all of the members of your committee, all of the candidates, and all of the people that participated in the process. I know all the members of this committee join me in their thanks. And Madam Minister, I wanted to also thank you for your openness to considering suggestions for this committee for the process going forward. And I know in the same nonpartisan way this committee has worked together to deliver other recommendations, we will work together to deliver recommendations related to the process as well. So thank you so much, and we're going to turn to questions, and Mr. Nicholson, our former Justice Minister, will start.
Thank you very much, and welcome to you, Minister, and of course, Ms. Campbell, and thank you for appearing before the committee and for all your efforts in this regard. I had to think, Minister, as you were saying that Ms. Campbell has promoted women throughout the legal profession. There were some exceptions, including myself. I just, for the record, I just wanted to say I was very honored to be her parliamentary secretary for I think about 3.5 years, and to serve in cabinet with her. And so I've been very grateful for those promotions and that opportunity. And I'm very pleased, Ms. Campbell, that you're here today, and I was going to say the same things basically that the chairman did, that your service to this country is continuing right up into including this, and I don't have to tell you how important this whole process is and how grateful we are that you've taken time to do this. I was very interested in the way you handled this. And you answered one of the questions that I had, was whether there were any personal interviews. And I think you seem to cut a good number there in terms of, you've got 31, 32 people. You don't want to interview all of them. In many ways, that's unfair to them if they're not going to be on that short list. But to have the 10 there, I think, is an excellent idea, so that you get that opportunity to see that interaction. So I was pleased to hear that. One of the interesting things as well that you said, it's difficult in August sometimes to get something done. When I heard that this was being done in August, I actually thought that was a good time, because a lot of the courts don't sit in July and August, and I thought to myself, you might be able to do it. Is there a better time to do it, do you think, or is it just one of those things where it's be up to, of course, to the minister? But what did you think? Is there a better time of year to do this, do you think, maybe in January? Or?
Well, I think probably Christmas is not a great time. But, no, I think you make a good point, that it's good for some, not good for others. I think, more lead time would be great, and I think in the future, I'm sure that will be possible. And having done the process once, people know what to expect. We know, for example, the Chief Justice will be retiring in 2018, and barring any other early retirement since then, that gives a certain lead time for people who are interested in being considered for the court to think about it and prepare themselves. So the first time is always perhaps a little bit more difficult, but you make an interesting point about the courts not sitting. Unfortunately, some of the judges go off to the boonies for their summer cottages, and so coming back was a challenge.
You didn't have any shortage, though, presumably, of people who wanted to have this. Were they from across the country, or were they mainly concentrated in Atlantic Canada? Yes, it was from across the country. What will happen with these applications now? Are they individuals who thought that they would like to have their names considered for future appointments, or is that something that would have to be started again?
Well, I'm just going to say that from the perspective of the committee, the applications were received and in confidence. But it might be something that the minister would like to do. Certainly, if people agree to have their names put forward, because there were a lot of wonderful people that we thought, oh boy, talk about a farm team for judicial appointments in the country. So that might be something that your committee might want to think about as well, because people who've gone to this trouble, one doesn't just want to sort of shred the applications. But I think the minister will pursue. It's just that you want to make sure that people agree to have things put forward. But all you have to do is ask them if they say,
oh, exactly.
Yes, you can do that.
I have a question for you, Minister. You indicated, there have been a number of ways that Supreme Court justices have been appointed in the past, and for the most part, the Prime Minister chooses somebody, and that's it, and he or she can get advice from whoever he or she wants to, and that person's appointed. In the previous couple of parliaments, there was a slightly different process in which members of the Justice Committee came together and made recommendations with respect to the candidates. I have to tell you, I was quite impressed with it at the time. I was Justice Minister for a number of these applications to be seen, and I thought it was a good way to involve people who are here as representatives of the people and representatives of Parliament and members of this committee. But you said that you believe that process was opaque. I'm not sure whether you're referring to that exactly or what, but give me your thoughts. Did you have problems with the process that was in place for a number of the justices of the Supreme Court by having members of this committee here look at those applications?
Thank you for the question, and perhaps I can come back and just address something that you had asked Ms. Campbell with respect to what happens to the applications that didn't move forward. But in terms of the process and the open and transparent process that the Prime Minister introduced, reaching out and seeking applications in a public way so individuals can bring their names forward. I feel invited substantive jurists from across the country. I recognize and acknowledge the important work that this committee does and valued being able to engage with the committee in early August to seek input in terms of the process and the applications. And again, today value having input from committee members in terms of the process, and that doesn't necessarily have to stop today. Would invite you to provide feedback on how the process unfolded. So I envision that continuing. Furthermore, providing the committee tomorrow at the University of Ottawa the opportunity to get to know Mr. Justice Rowe and be able to ask him questions in terms of, or have him introduce himself and then ask him questions, I think is a further opening up of the process. In no way, we put a process in place where there wasn't that public process that people could understand or read about or download from a website as an example, but in no way has that process taken away or undermined the quality of the appointments that and the judges that have sat on the Supreme Court of Canada. And just in terms of the applications, the other 30 applications that have been put forward, as Ms. Campbell indicated, the next scheduled retirement will be in 2018 with Madam Chief Justice McLaughlin's mandatory retirement. There will be the same process with amendments potentially that we intend to follow. So those applicants that are interested in applying will have to do so again, but recognize, as was stated, the substantive quality of the individuals that had put their name forward, and there's some merit, and I certainly recognize that in pursuing those individuals in other capacity, perhaps.
Unless it's really
I'll
short.
come back then.
Thanks.
There's a chance. Okay.
Perfect. Mr. McKinnon?
Welcome, Mr. Wilson-Raybould and Ms. Campbell, and welcome back to the committee, Minister, and welcome back to the Hill, in addition, Ms. Campbell. Ms. Campbell, as chair of the advisory board, I wonder if you could give us, I know you spoke about this in your remarks, gave us some indication of the challenges such as time, deadlines and so forth, but I wonder if you could share with us any lessons learned, things you might do differently as the process unfolds another time.
Well, I think the process of the board itself went remarkably well, and if there were many more applications, I think you would need more time. There's no question about that. We worked as expeditiously as possible, and I think we felt we had sufficient time. But, I was glad that I won the pool, because some people were guessing, 54 and somebody even 100. So I think that would have been a number of applicants that it would have been more difficult to deal with. So I think the possibility of having more elastic time to do this, to make sure that, depending on the number of applicants that apply, that the committee could deal with it fairly. Because again, I go back to this notion that if somebody responds to a solicitation for applications and goes to the trouble of filling in a very daunting form, they need to feel that that's going to be treated with respect and really seriously reviewed, that would take time.
Is there anything you'd do differently?
Well, that's always dangerous to say no, because, invariably somebody will say, well, what about this? I think because, no, I think we actually came up with a pretty good way of implementing our mandate. I think, again, if we'd had more time, we might have been able to reach out even more. We did recognize when we first came together in our first conference call that part of our terms of reference was to seek out good candidates. And given the nature of how much time there was before the deadline, we went to different groups, although we responded to individual nominees. I think that had there been more time, we might have been able to actually consult, say there were, 2 months or something between the beginning of the process and the deadline. We might have actually been able to consult more personally with some organizations or some groups, or go out to answer questions and perhaps encourage even more to apply. But I think we got a really remarkable group of candidates. But could we have found more? Could we have encouraged more people to apply? Quite possibly. And that would be something that time would make possible. But I think we did, as I say, err on the side of overkill when it came to just getting the information out to as many groups of lawyers as possible.
Okay. Thank you. Minister, your perspective on the operation of this committee is, of course, different. I wonder if you have any lessons learned that you'd like to share with us, or any ideas where you think the process could be improved.
Well, I appreciate the question, and very mindful of the comments that Ms. Campbell had just made. And this kind of speaks to the question from Mr. Nicholson as well. I believe that the heart of this new appointments process, beyond the public application forms for individuals across the country, was this independent, nonpartisan advisory board, which was a board that was reflective of the diversity of the country, I would say, and the thoroughness at which they undertook their task resulted in a substantive shortlist that was provided to the Prime Minister, of which he nominated Justice Rowe. I would echo the comments and that we have, barring anything else happening, an opportunity to take advantage of the time between now and 2018 with the retirement of Madam Chief Justice McLaughlin, to encourage all of those individuals out there that meet the statutory requirements to to start to consider putting their names forward, to brush up on their French if they are wanting to apply to be the next Supreme Court Justice. But having said that, and recognizing that more time is always can be good to achieve more applicants putting their names forward. The lack of time, I think I can safely say, did not diminish the quality of the individual applicants that the shortlist that we had the opportunity to review, but certainly I would suspect the 31 applicants that whose names went before the advisory board.
Thank you. Those are my questions.
Merci, Monsieur McKinnon. On va passer à Monsieur Rankin. Monsieur Rankin.
Thank you, Mr. McKinnon. We'll go to Mr. Rankin.
And thank you for coming to the Standing Committee on Justice and Human Rights, and I'd particularly like to thank you, Ms. Campbell, for your service in this important role. Minister, in your opening remarks, you referenced two purposes. The first was about the candidate, and the second, of course, was about the process. And I'd like to talk about the process that led to the selection of Justice Rowe as the nominee of the Supreme Court of Canada. You said the process would allow us as parliamentarians to hold the government to account. I understand that under the administrations of both Prime Minister Harper and Prime Minister Martin, opposition members were involved in an advisory committee that created the short list of possible candidates. Minister, you're well aware of the difference between consultation and mere notification. Do you believe MPs should have a role in the creation of the list as well as in the selection of the person to serve as a justice of the Supreme Court, particularly given the increasingly important role that the Supreme Court plays in the lives of Canadians? Do you think members of Parliament, as the elected representatives of Canadians, should be involved in the substance of the appointment decision now and for future appointments?
Well, thank you, Mr. Rankin, for the question, and I certainly appreciate and recognize the importance of ensuring that members of Parliament have involvement in the selection process. I do believe that, as I said earlier, the heart of this new nomination process for Supreme Court of Canada justices is the independent and nonpartisan advisory board that is, in this case, and I imagine in future cases, comprised of exceptional individuals that are from the legal community and that are non-lawyers that have been able to provide a short list of candidates that they came up with, having had extensive review. So I think that continuing, and I know that we will continue with that independent advisory board process. And having said that, I believe that members of Parliament have been engaged in and will continue to be engaged in the selection of the process in terms of having the Minister of Justice come before the committee to speak about the process in advance, having and being able to come back before the committee, as we are today, to talk about the nominee and to talk about the selection process to identify that nominee. And furthermore, in an unprecedented way, have publicly available the opportunity for not only members of Parliament, including this committee, to meet Justice Rowe tomorrow, but also have members of the public be able to listen to Justice Rowe introduce himself and then be able to ask him some questions.
But you'd agree that having what I understand and agree was a nonpartisan and independent process is a very different thing than involving members of Parliament as the representative Canadians early on in the process rather than being simply given a name and having the opportunity to meet that person in an informal gathering off the Hill. It's very different than the kind of role that MPs have played in the past under previous administrations, where they were involved in the creation of the shortlist and involved in the substance of the decision-making. Very different.
Well, I mean, again, I believe that having that independent, nonpartisan advisory board providing the short list is an important aspect of this new selection process. I would encourage members of this committee and beyond this committee to recommend or to encourage individuals to put their name forward for the next appointment. Mm-hmm. And, you know, I understand the important role that the institutions of our democracy play in wanting to ensure that there is a recognition of the independence of the judiciary, a recognition that bringing in 7 esteemed individuals to beyond partisan politics to identify a list is an important aspect of this open and transparent process.
Minister, you spoke about diversity in your search for nominees, and I appreciate and respect the commitment that both you and Ms. Campbell have to greater diversity on the Supreme Court, so judges can better reflect the Canadians that they serve. I think I understand Ms. Campbell to have said that there was a regional diversity quota for the shortlist. Was this the only one, or was there, for example, requirements about gender balance, ethnic diversity, or Indigenous representation, for example? And I'd like to ask you, can you point to anything in the current process that would demonstrate that the goal of diversity was achieved? Are there lessons for future processes, or are you satisfied that this has achieved the goal of diversity, this process?
Are you asking me or Ms.
Either
Campbell?
of you, please.
Well, perhaps I could just say a little bit about the actual process, how we did it. Our terms of reference made particular point of recognizing the diversity of Canadians, and it identified a number of characteristics where individuals are often underrepresented or not represented in the judicial community. One of our candidates actually made a very interesting comment and said that diversity isn't so much reflected in decisions, but in what you bring to the conference. And I think those of us who have worked for the advancement of women recognize this, that it's not so much that a woman would decide this and a man would decide that, but that you bring a different reality and different questions, perhaps, to the broad issue of discussing issues. I think diversity played out, this commitment to diversity, and incidentally, as the minister has said, our terms of reference also included finding qualified candidates, plural, from Atlantic Canada, and we assumed that meant at least 2 candidates from Atlantic Canada, and there were a lot of Atlantic Canadian applicants, obviously, so that was not difficult. But there was a broad diversity in the candidates, so I think the terms of reference sent a message to people who were thinking of applying that they should not be discouraged if they are members of a hitherto not represented or unrepresented social category in applying. And that may sound I say, well, why would they? But the fact of the matter is, particularly in the legal profession, there is a lot of lack of diversity in many aspects of it. So the terms of reference were a clear message to the Canadian legal community, and that was reflected in the applications. Our goal was to find candidates of great competence, and many of them represent what you might call the checking of the box, but it's a broader thing. So there were the names that we provided to the Prime Minister provided some very interesting choices. But even in the case, for example, of Justice Rowe, who doesn't click off any of those boxes, and except that no one from Newfoundland has ever been there, what was also important for us was the breadth of his understanding of the country, because we asked candidates, tell us about your understanding of the diversity of Canadian society. So it wasn't just, are you from a category that you would click on the application, but what is your lived experience of the reality of Canadian society? And that was a very interesting question to hear from people, whether this had touched them in a way, and whether they had dealt with it. And Justice Rowe's experience, particularly in the work he's done through Action Canada, which has particularly taken him to Indigenous governments, Haida Gwaii, the governments in the north, etc. And he talked very in great, well, you can ask him about tomorrow, I won't give his talks for it. But that was important to us, so that when we, again, talking about what do you bring to the conference, when the members of the Supreme Court are sitting talking about an issue, are there things that are not being said because nobody knows about them? That there are, I think of when Bertha Wilson came to the court, and the decisions on property, for example, in couples, common law couples. These were really important things that came from a particular person's recognition there was an issue. So that, I think, is really important. And I don't, for a nanosecond, say that is the only thing. But I think what was communicated was that, the welcome to candidates of many different backgrounds to apply. And, we're committed to confidentiality. We can't sort of give you all the list. But there was a really wonderful richness. And I think that is the most important. Only one person can be appointed, but that person has to reflect that respect and appreciation and knowledge of the diversity of Canadian society. But the candidates were themselves a very interesting group, and, as I say, remarkably proficient in French, much to my delight.
Thank you.
And to that, it's a really important question. Acknowledge the comments of Ms. Campbell, and it is for that reason, the need or the desire to achieve that diversity, that we were very thoughtful in terms of developing the process and the qualifications and the assessment criteria that we've made publicly available, and it's reflected in the publicly available application that Justice Rowe put forward in terms of asking specifically about your reflections on diversity and your experiences with respect to diversity.
Thank you.
Thank you very much. Mr. Fraser.
Merci beaucoup, Monsieur le Président. Thank you very much here today, and Ms. Campbell, thank you so much for being here, and certainly for all of your good work leading the advisory panel. I think it has led to an excellent choice for the Supreme Court of Canada, and I just commend you and all of the members of the advisory board for the great work that you did in the service to Canada. I think it reflects very well on the process to have somebody of Justice Rowe's caliber to be selected, and certainly will serve Canada well in the future to learn lessons of what perhaps could be improved. But I would like to ask you, Ms. Campbell, about, I'm from Atlantic Canada. I'm a lawyer from Nova Scotia, and I know that myself and my colleagues were certainly watching with interest to see what would happen with regard to the custom of regional representation, and we believed, we believe that was an important aspect, and it certainly was part of the process. So what I'd like to ask you, Ms. Campbell, is how did the advisory panel view the regional representation as far as getting, at least as you said, 2 names on the short list? How did that happen? Was it viewed in isolation from the rest of the candidates, for example, or was there some other way that the conversation happened regarding the importance of regional representation?
Again, the terms of reference were clear. At no time was that a difficult thing to fulfill. Atlantic Canada sent us outstanding candidates. And so it wasn't something where we sat around saying, oh my gosh, we better rustle up a couple of Atlantic Canadians to put on our list. Au contraire, it was, good grief, not another wonderful Atlantic Canadian. So they were well represented. And as one of the committee members said one day, Atlantic Canada has sent us its best. So, I think, at some point, someday, one might have to answer such a question. It was not an issue. There was no difficulty in going for the most excellent candidates. And I can say that when Justice Rowe came in, we immediately, thought, whoa, this guy's a superstar.
Absolutely.
And he wasn't alone.
Very good. And with regard to the terms of reference, I know that the advisory board members must, under paragraph 8, one of them was review applications received from candidates and actively seek out qualified candidates. I take it from what you said that there wasn't a specific emphasis necessarily placed on a certain region because there was so many candidates, good candidates from across the country, but in particular from Atlantic Canada.
Well,
Is that fair to say?
we asked the groups that we asked to solicit their members and to make sure they got the information. We grouped them across Canada, the Canadian Bar, all the law societies, but also I think there's a list of about 19 groups, many groups, ethnic groups of lawyers or lawyers with particular interests. I think all of whom have members in Atlantic Canada. But what we were, because of the terms of reference, that the application was open to all Canadians, blanketed the whole country in terms of asking organizations to assist us. Now, down the line, if there is more time, one could even do more, perhaps, to seek people out. But certainly, as I say, when individuals were recommended to us, we immediately sent them the information and said, your name has been forwarded to us, please review this. And we warmly encourage you, if you're interested, to apply, because we thought that was the appropriate way of doing it as opposed to singling out. And actually that might be something that this committee might have some interesting advice about, what is the optimal way to keep to maximize the number of good people who will apply. And that is something where often members of Parliament in their own constituencies may know of people who really have promise. And I'm sure we already do. Try to, encourage them to go and get vetted for the Section 96 courts and the trial and appellate levels. But again, it's feeding the pipeline. That's.
And now that we know how the process works and it's being better understood, I suppose that will help in formulating people to encourage others to make the application.
Yeah.
With regard to the paragraph 8 of the terms of reference that I mentioned, there's also, it was mentioned that you should consult with Chief Justice of Canada and key stakeholders that the members consider appropriate. And you mentioned that you did have a meeting with the Chief Justice of Canada. I'm wondering if you can speak about key stakeholders, who those might have been, and at what point in the process did those meetings take place?
Well, We spoke to chief justices. We spoke to at least 2 former justices of the Supreme Court of Canada, and most of those consultations came as a result of them being references for other candidates. But we also knew that there would be a process of consultation by the Minister of Justice after. That is an area where perhaps, the consultations took place, whether there could have been more broadly, that's another interesting question. We certainly consulted as broadly as we thought we needed to, but I think that's something that a committee with a longer time horizon might want to rethink and perhaps even change the timing of it. We thought the consultation with the Chief Justice was the most important because it related to what the successful candidate would have to do. And, it is a demanding job. Work on nights and weekends is the norm. The fact that a justice on the Supreme Court of Canada has to live in the National Capital Region, that's not always easy for people from far afield. The nature of the kind of the isolation sometimes, the collegiality, all of these kinds of things, I think, are very important, and the Chief Justice could give us that. Even talking realistically about how French actually works in the court. When did the justice actually need it? Because you can talk about it, but tell us how it really works for an Anglophone working in French or a Francophone working in English, so that we could have a better sense of what that meant. So she was extremely helpful in that. But in terms of the individual candidates, we consulted as we were trying to narrow down our list.
Thank you very much. And just with regard to the open process, I note as well that the application of Justice Rowe is actually online, and it's very helpful to be able to read that, and you understand the quality of this person and why he should serve on the Supreme Court of Canada. So thank you very much.
Thank you very much, Mr. Fraser. We'll now move to the second round of questions, which starts with Mr. Hussain.
Thank you, Mr. Chair. I'd like to begin by asking if I can share my time with Ms. Khalid. Okay. And I'd also begin by thanking Minister Wilson-Raybould for coming back to the committee, and especially thanking Ms. Campbell for not only heading the committee but also coming before us today.
Pleasure.
Thank you. I'm encouraged by what Minister Raybould said. You said that the process is open to further refinements down the road, so that's encouraging because we can always improve what process that we have. And I'm also very thankful that to hear that, Ms. Campbell, that you used numbers instead of names in the initial process, so that removes any subliminal bias that we may have about people's names. But going back to the refinements, do you think that if you had a longer timeline, you would have had more of an opportunity to meet personally with some of the underrepresented groups across the country, and then that would allow you to fulfill your terms of reference better? Would that?
Do you mean in terms of increasing the number of people who would have applied from some of those groups?
Yes, but also in terms of reaching out to underrepresented groups that are normally underrepresented represented in the judicial system. So having them know more about the process and what they would need to apply.
Well, I'm not sure whether that would have increased the number of candidates. And I should say that there were representatives of underrepresented groups actually on the committee as well. So this was not a uniform, homogeneous group of people. But I think, yes, down the line, the opportunity and judges from the Supreme Court of Canada do go out and meet with the public. The Chief Justice goes out and talks. And I think they understand that there are certain things they should talk about, and I think talking about what it means to sit on the Supreme Court of Canada. I think that underrepresented groups, it's great if they could see themselves as part of the justice system, not just in terms of the Supreme Court of Canada, but sitting on benches at all levels. That's one of the most important things that we do in the rule of law. So I think it would be very interesting if a committee, now we were appointed for 6 months, so But another committee could, I think, under the legislation, be appointed for a longer term, in which case they could perhaps have an outreach program. In other words, where they could, meet with different groups in different parts of the country to talk about what it means to go to the Supreme Court of Canada, what kinds of things that a committee looks for, and how they might prepare themselves or encourage people they know to do it. I think that would be great. I think we got a very interesting, diverse group this first go round. Could it be better? Could it be more? Sure. And I think what we want for Canadians, I mean, not only would you keep the Prime Minister up at night trying to figure out which of the shortlist to appoint, but you'd keep the committee up at night trying to figure out however to get to a shortlist. But that's a problem we'd like to have, I think.
And to Minister Raybould, would you be open to, would the government be open to having or putting extra effort to having more time and effort put into outreach into unrepresented groups to inform them about this new process or educate them more? Because I think part of the challenge is education about the process, not necessarily a lack of applicants, but maybe with more education you can have more applicants and you have then you have more of a challenge to pick the right people.
Well, thank you for the question, and I mean the short answer is yes. Certainly would be in advance of the next appointments process that we go through. We have an incredible opportunity, all of us, including myself, to do that necessary outreach and to, one, explain the process and encourage people to apply through that process. I think it's important not only on the Supreme Court of Canada, but it's also important for appointments to superior courts across the country, which is something that with the Prime Minister introducing this process in terms of the Supreme Court of Canada, we've had the opportunity to amend and introduce a process for a new process for superior court appointments, and that is to speak to and encourage a diversification of individuals that are appointed as judges to the superior court. So this is an opportunity for all of us. I am open to all of the recommendations, not only from this committee, but certainly look forward to reading the report of the Independent Advisory Board with respect to the process in this regard as well.
I don't have any further questions. I just have one comment to make.
I understand, but if Ms. Cleed is going to ask her question, you're almost out of time.
Go ahead.
Ms. Cleed?
That's fine.
Thank you. Thank you, Ms. Campbell and Minister Wilson-Raybould for your time today. It is very much appreciated. I will ask a couple of short questions, if that's okay. And in light of two wonderfully accomplished women sitting before us today, I am wondering, curious, out of the 31 applications, how many of them were women? Do we know?
I think we're trying to discuss how specific we can be because to protect the identity of candidates.
Right, so let me rephrase
I would slightly less than half.
Okay.
Slightly less than half. Probably, I'm not sure what the proportion of women is in the profession now eligible to go to the courts. When I was Justice Minister, it was 12.5%, and 25% of my appointments were women. I don't know if women are up to 50% in the eligible group of lawyers 10 years call. If it's not quite, I think the proportion was probably close to the proportion in the eligible group. But that's another category of people that need to be encouraged. There's no question about it at all levels.
Do you think, what more do you think can be done to encourage women, other than, the eligibility criteria and working at the grassroots on that end? But is there more that can be done to compel women to apply? From my personal experience, I always find that women have a hard time trying to reach for those positions.
Well, the minister will speak to her own role in appointing women to the farm team of other benches. But you know perfectly well that trying to get women to run for Parliament, this is a very large country, and in the Supreme Court of Canada, people do have to uproot themselves and come to Ottawa. And I think that's difficult, and sometimes women are less mobile than men, not always now, and it is changing, but it can be a challenge. So I think we need to get out to those communities And I think a lot has happened at the trial and appellate level in making women part of that landscape. But underrepresented groups need to have champions and need to encourage. We did have excellent candidates, so it's not that there were none, but it wasn't greater than the proportion in the eligible group, and maybe that's how it should be.
Fantastic. Do I have? No?
We make better time on that one. Sorry. Mr. Cooper.
Thank you, Mr. Chair, and thank you, Madam Minister and Ms. Campbell, for being here. I want to, first of all, ask you, Madam Minister, a couple of questions about the process. And when I turn to the August 2nd op-ed piece of the Prime Minister published in the Globe and Mail, he stated that once the short list of candidates had been compiled by the advisory board, you, as the minister, would consult with a number of different persons, including members of the Justice and Human Rights Committee. I just want to confirm that you would acknowledge that that didn't take place.
Well, in fact, it did take place, and I took very seriously the necessity to consult with members of this committee, and in fact consulted with both critics, Mr. Nicholson and Mr. Rankin, and I had the opportunity to consult with the chair of the committee, Mr. Housefather.
I would note, Madam Minister, that the Prime Minister in the Globe and Mail referred to the members of the House Justice and Human Rights Committee, and he went on to add opposition justice critics. So according to the criterion set out by the Prime Minister, it wasn't just the justice critics that were in this process to be consulted, it was also members of the Justice Committee. So again, I would ask that you would acknowledge that that didn't happen.
Thank you for the question. I think we're going to have to agree to disagree, Mr. Cooper. I consulted with members of the Justice Committee, including Mr. Housefather.
I would also note that not only did you not consult, you in fact disinvited certain members from having the opportunity to engage in that process, including the vice chair of the committee, who was advised 7 minutes before the nominee was to be announced by the Prime Minister. And I recognize you're under no obligation, the Prime Minister is under no obligation to consult members of Parliament in this process, but when you make a commitment, it's about keeping the commitment. Now, with respect to another thing that the Prime Minister said in his Globe and Mail op-ed piece, he talked about the fact that members of Parliament would have a direct opportunity to engage with the nominee. Now, further in that op-ed piece, he referred to a Q&A session in which members of both the Justice Committee and the Senate Legal and Constitutional Affairs Committee would have an opportunity to take part in a Q&A session with the nominee. That is, of course, happening tomorrow at the University of Ottawa, and when you look at both committees, we have, I believe, 12 members on the Senate committee, and we have 10 members on our House committee, and yet there will only be an opportunity for 14 rounds in which it appears that there might be an opportunity to ask a 1-minute question. Would you not see merit in having an opportunity for members of this committee and the Senate committee to have a fulsome opportunity to engage with the nominee by having the nominee come to Parliament Hill, in addition to this Q&A session that has been set up for tomorrow? Wouldn't that provide a better opportunity for real meaningful engagement?
Well, to the two parts of the question, and I appreciate the two parts. In terms of the consultations, as I said, I took very seriously my obligation to consult, and certainly the consultations that I undertook informed to a great degree my recommendation to the Prime Minister. And one can appreciate with the sensitivity around a short list and the need for confidentiality in advance of those consultations, I sought to gain signed non-disclosure agreements among the individuals that I consulted with, particularly with respect to those that were consulted on the entirety of the short list. And I'm very pleased that I was able to consult with 3 members of this committee. In terms of the discussions or the opportunity to engage with Mr. Justice Rowe, tomorrow at Ottawa University, I am very pleased that members of this committee, members of the House, and a whole host of law students will be there to be able to be introduced to Mr. Justice Rowe and to be able, members of this committee and Senate, to ask him questions. I want to underscore that this is unprecedented. This is historic, and it provides an opportunity to invite Canadians into a process wherein they would have the opportunity to get to know the next Supreme Court of Canada Justice. I very much look forward to seeing how the discussions unfold, and am entirely encouraged that there are a substantive amount of questions that this committee and others will be able to ask Mr. Justice Rowe.
Yeah, well, thank you, Madam Minister. I now just want to turn to Ms. Campbell. One of the very positive things that I heard today was when you talked about the fact that of the 31 applicants, that almost all of them met the qualifications in terms of being functionally bilingual. And while I appreciate you may not be able to get into some of the specifics, would you be able to perhaps comment on the regional breakdown of the number of applicants who applied, because it certainly is encouraging to hear that high degree of proficiency.
I'm not sure I said they were all functionally bilingual. I said they all had some French. And very few had no French at all. And that was right across the country. The candidates who took the French test, I mean, there was a French test given to ensure functional bilingualism, and not all candidates passed it. Most of them did who took it. But it was actually a pleasant surprise to me. If you see the application form, Justice Rose is on the internet. It's easy to see that there were 4 boxes. Two of the first 2 boxes represented what we would call functional bilingualism. They able to read and understand argument in French, and then the other 2 were refinements of that. But I think it's a reflection of an interest in learning French that has, going back to my own days as minister, where one saw this growing. And again, the Supreme Court of Canada is a unique court, and but it's interesting that even in some of the regions, for example, I'm doing a project now for the University of Alberta, and in another totally different context related to that project, I met with a Francophone judge who is the head of the organization of lawyers, a Francophone lawyer who is the head of an organization of lawyers d'expression française in Alberta. And many people may not know, I mean, the University of Alberta has a Francophone campus. So there are people, and the interesting thing that this lawyer said was that translation isn't adequate. He said that he actually thinks he lost a case because a judge missed a nuance of an argument. And he's actually had judges say to him, I'll rely on your translation because the translator isn't very good. So I'm sure that as legal translators go, the Supreme Court of Canada has very good ones. But I think that relying on that when there is a possibility of having judges who have some functional understanding is perhaps not serving our Francophone citizens the best, and they don't all come from Quebec or New Brunswick. That's what has been very interesting for me. So lawyers have been taking on the challenge, and it's quite wonderful. And I say Justice Rowe is a very excellent example of that. He comes from Newfoundland. They don't have a French-speaking population. They're not like in New Brunswick or even Nova Scotia, where there are French-speaking communities. But I think it was very encouraging to me to see that.
Good to hear.
Thank you very much. Mr. Biddle.
Thank you so much, Mr. Chair. I practiced law and litigation for approximately 10 years and occasionally came across judges who we jokingly referred to as having judgeitis, arrogance or pomposity. How did you find candidates that were not, and just to be clear, none of them were from Niagara, but in case I ever have to go back, that's a possibility.
As they get too uppity.
But how did you seek out candidates that were not only just excellent jurists, but also good people who had a sense of empathy along with an appreciation and ability to apply the law?
Well, two things. One, the references that we spoke to. I mean, we really pursued those kinds of issues, but also in the interviews that we did, they were long enough, and I think the kinds of questions we asked tried to get at that. We looked at things like their views on collegiality, which is very important for the court. We looked at, what their references said about how they were regarded in their communities by the profession, and more broadly. I suppose there are, again, with more time, one could do more of that. But we certainly cared about that because one of the things about the Supreme Court of Canada is if you can't work with other people, it's very destructive because it's not that you don't want groupthink. You want people who bring a strong point of view. But if in a decision there are a lot of different judgments, that's chaos for the courts and the people below, as you well know, who have to rely on that. This is the architecture of the law. So that ability, and one of the things I would say about Justice Rowe, when we asked him this question, he gave a very interesting answer. He said, because he serves on an appellate court, so of course his experience is very real. But he said, and I hope I'm allowed to say this because he'll probably repeat it if you ask him, but he said, well, I know what the issue is that's important to me, and I'm prepared to put a lot of water in my wine, and I have no pride of authorship. And I thought that's a very interesting and constructive philosophy for an appellate court judge who has to sit with others to have. That it bodes well for the ability to help to create the kinds of judgments that will give security and clarity to those of you who are practicing and need to know what the law is.
Thank you. Were you able to identify any particular experience, training, education, community involvement that really elevated the best candidates for consideration? And if so, perhaps that's a good thing to identify to future candidates, not only for the Supreme Court, but the new application process as well for other courts?
Well, we looked for all of the above, but it's interesting. Judges who serve in very small communities often find that when they go to the bench, they are advised not to be too involved in their communities because it creates the community organizations, like many of them were before they were elevated to the bench, because it creates the possibility of conflict of interest. Small communities, and you see the judges move back and forth because they have a lot of conflicts. So it's very situational. But what we found with the candidates that we felt most confident with was that there was an interest in the world outside their own role as judges, that they cared about the community, they cared about issues that might be on an international level, often before they went to the bench. And many of them were people, and again, and Justice Rowe is one of them, but many of them were people who came from quite modest backgrounds, often very poor backgrounds, but who just had that wonderful, remarkable intelligence and resilience where they were great Canadian success stories, and it was wonderful to see their humanity. So we looked for that kind of humanity in people because they need. The law is not an abstract exercise. It's real people are affected, and that we very much looked for evidence of that. But it came in many different ways, depending on the nature of where they lived and what they were able to do.
Thank you. You mentioned that the process went well. Perhaps ask a bit more of a specific question. Do you see any changes, or would you recommend any changes to the questionnaire?
Oh, I'd have to sort of go back and look at it. I know that from the point of view of the applicants, shorter would be better. it was quite daunting. I'd have to go back and sort of look at it again and say, we didn't need this or we didn't need that, or that may have been a duplication. On the other hand, in terms of transparency, the fact that you can all read the application of the successful candidate means that you have as clear a sense as we did when we first met him in the process of what kind of person he is. And what you might ask yourself, if I were reviewing this and I just was given this application, what would I think of this person? So the nice thing about it is that it certainly gives, it's the person telling you about his or her life in the law. Then there's more that we find from other people as well. But I think we might be able to make it more succinct. We might be able to, reduce the misery of putting every case that you were involved in, et cetera. Although nowadays with electronic, trial court judges often, and there are some jurisdictions where everything isn't published, so it's not so easy. Anyway, I think that is certainly something that one could look at, and just from a humanitarian perspective. But it certainly is a wonderful I don't think we've ever had such a document about anyone who's gone to the Supreme Court of Canada. I mean, we know lots about them, but to have in one place the story of their life in the law is really, I think, and their childhood and their upbringing, it's all in there.
And thank you, Ms. Campbell and Minister Wilson-Raybould, for your testimony here at committee. You outlined a little bit the process, Ms. Campbell, about receiving the applications, 31 of them, distributing them to the 7 committee members for evaluation, and then submitting the results. I'm assuming they ranked the results. And I'd be curious to know a little bit about the criteria that you were weighting. Was it qualifications? Was it characteristics? Was it achievements? Was it competencies? Tell me a little bit more about the things you were looking for and how you weighted those things.
Actually, we didn't rank them. In the first go-round, we just said yes, no, maybe. That was the first thing. In other words, yes to go to the next stage. No, if we thought for whatever reason that this candidate, and it was usually perhaps because the person had not had a lot of experience, was still, just compared to the others, didn't have that kind of ability, and then maybe was, oh, this is a tough one, this is good things, and that where we had the very interesting conversations. The assessment criteria, which are actually in the terms of reference, and I think were very much what we looked at: personal skills and experience, so superior knowledge of the law, and we asked, we looked for knowledge of the law and legal judgment. Analytical skills, the ability to resolve complex legal questions, the ability to work under time pressures, clarity. So it's in the terms of reference, commitment to public service. Then there were personal qualities, irreproachable personal and professional integrity. And this we explored quite forcefully with the different referees that we spoke to about people. What can you tell us about this person? In your view, is this person, is there anything that would come back to haunt, etc. Respect and consideration for others, I think that's important. Ability to appreciate a diversity of views, perspectives, and life experiences, including those relating to groups historically disadvantaged in Canadian society. And we questioned on that. And again, it was very interesting to see how those answers unfolded, often through personal experience, often through their lifetime experience. But that was important to us. What is that texture? What is how has Canadian life and all of its diversity impacted on this individual and his or her understanding? Moral courage, discretion, open-mindedness. Those were the personal qualities we looked at. And then the institutional needs of the court, ensuring a reasonable balance between public and private law expertise, bearing in mind the historic patterns of distribution between these areas in the Supreme Court, expertise in any specific subject matter that regularly features in appeals and is currently underrepresented on the court, and ensuring that the members of the Supreme Court are reasonably reflective of the diversity of Canadian society. One of the things that interested me very much about Justice Rowe was his experience in government, both as the head of the civil service in Newfoundland and then his work as a foreign service officer. There will be probably interesting cases with respect to jurisdictional disputes, etc., the balancing of federal-provincial relations in all sorts of areas of policy, and both Indigenous issues, environmental policy, etc. And I thought that his experience that experience plus his broad experience in the country positioned him well to be a constructive participant in the law in that area. So, but there's. We sometimes, at the very beginning, we kind of joked and said, well, if we could deconstruct all these people and we take this part of this and this part of this part of this. But that's not how it works. People are fully fledged human beings, and you have to see them in their entirety. And it's actually very reassuring. I think you would enjoy it very much to appreciate how a person can be wonderful in many different ways and can bring a kind of humanity and wisdom from many different sources. At the end of the day, that person, if he or she goes to the Supreme Court of Canada, has to be a legal thinker, has to be a jurist, has to be able to write, has to be able to collaborate effectively with other judges on the court. But the wonderfulness that would make somebody effective on the court can take many different forms. And that was what, for us, that it's not like you're comparing apples and oranges. It's like you're comparing many different wonderful types of apple. I love Macintoshes, and I like to cook with the Bramley. In other words, they were all quite splendid, but how they got there was unique to each one of them. And it was a great privilege and hard work to look at these people and say, what can we give to the Prime Minister that will give him some choice, but where no matter which candidate he chooses, he can't go wrong. That person will be an adornment to the court. And, and it was very...
Mr. Fox asked another question, if it's okay.
Sorry, I'm blathering
Thank you.
on, but it was a great experience.
What I was really after, and I should have made myself more clear, is some of the weighting, what you put priority on, which qualifications or characteristics. But maybe you can answer it on somebody else's time. I'd like to ask the minister a question. Minister, you provided the Prime Minister with a short list of 5. My question is, did you rank those individuals, and did he go with your ranking? And my second question is, would you commit to a hybrid process for this next year where members of Parliament, especially members of this committee, would be more engaged?
Well, thank you for the question, and the short list certainly was provided to the Prime Minister, and I was provided that list from the Prime Minister, and undertook to do extensive consultations, reviewed the jurisprudence of every single individual that was on that list, which in the case of Justice Rowe was quite large. I did not rank candidates for the Prime Minister, and was pleased to, having gone through the thorough consultation, having reviewed all of the jurisprudence and other professional and academic writings, was happy to fulfill my role as the Minister of Justice and be able to provide a nomination to the Prime Minister, a recommendation. And in terms of your question about a hybrid process, as I said earlier, I'm very open to hearing feedback from members of this committee. And once that feedback is provided, and certainly the feedback of the advisory board, I will take it into consideration.
Thank you very much, Mr. Rankin.
Yeah, and just to build on that, I'm glad that you're open to refinement in the process, and I would encourage you to provide a more robust role for MPs, as I said earlier. And specifically the hybrid idea that Mr. Falk suggested, I think makes a lot of sense. The process tomorrow is a process that has no legal standing. It's by invitation only, and it's not a committee of Parliament. So I would really urge that this committee of Parliament be offered the opportunity to add to the independent and nonpartisan role that Ms. Campbell's committee played, so that we can discharge our responsibilities. So I'm glad to hear that I heard you say you may be open to that, but I wouldn't mind clarification, a role for this committee perhaps earlier in the process so we could do our job.
Well, I appreciate the question, and I much more appreciate the engagement of the committee. I said that I'm open to feedback from the committee on any part of this process and how it can be improved. So I suspect I will be getting some recommendations in that regard with respect to the role for the MPs. But I wanted to underscore my comments earlier that the process that the Prime Minister has introduced, I feel that it provides a substantive ability for members of Parliament to be engaged and as evidenced by tomorrow and being able to ask questions of Justice Rowe, not only among members in the House of Commons, but in the Senate as well.
Thank you. No, that's fine. Thank you.
Yes, Mr. Basically, if you ladies would agree, just we do these short snappers, which are where the member of the committee gets a very short question and you have a short answer. We have only a couple of minutes left, and Mr. Nicholson had his hand up to ask for a question for quite a while. So, Mr. Nicholson,
thank you very much. Just on that question of our involvement tomorrow, I mean, as Mr. Cooper pointed out, you've got 22 members of Parliament there. We have been told that we, the Conservatives, the three of us, will get 2 questions. I mean, how excited or engaged do you think we are if we've got a 66% of chance of asking 1 question tomorrow, and we were suggested that it would be 1 minute to give the judge 3 minutes? I mean, how involved do you think? How significant do you think that involvement is? And wouldn't it be a better idea to have the justice appear before this committee here and have a committee meeting of the Standing Committee of Justice? What do you think?
I do though just want to clarify that it's a 5-minute back and forth with the justice. We listened to the feedback offered by members of the committee, and that process was changed to allow for a more fulsome process tomorrow. It is a 5-minute back and forth with the questioner. Sorry, let me pass it off to the minister.
Well, I mean, I guess I would underscore tomorrow is a substantive process to be able to engage. It is historic. It enables the public to be invited into the process. And not only for members of the House of Commons, it enables members of the Senate to be able to ask questions. So, again, I think that this is an incredible opportunity for individuals, not only around this table, but beyond, to get introduced to the nominee for the Supreme Court of Canada.
Thank you. I believe, Mr. Rankin, you were okay. The Liberals, you okay? So we would all, I think, want to take this opportunity to thank you very much for appearing before the committee. And we really appreciate, again, the work that you have done. And finally, we will, as you mentioned, Madam Minister, deliver back a report with our recommendations and feedback in the very near future. Thank you so much to both of you.
Thank you for your time, too.
Thank you, Ms. Campbell.
And thank you to all of you. Thank you. So there's